week 5. We're going to be dealing with copyright and infringement. We had a few preliminary remarks in last week's PowerPoint presentation video. Talked about the complexities of copyright, especially in the duality that you see where there's multiple copyrights that oftentimes have to come together in either the music side or the film side in order for the final product to see the light of day. So we'll revisit a little bit of that, and then we'll get into actually, ownership of copyright and what's involved with protecting your property, and actually some of the technicalities of bringing a trial, an infringement trial to court, and so that's going to cover most of what we've got today. This is a hybrid, as I've been doing for most of the presentations, except for last week, where I'm taking the high points of the 2 PowerPoints that are on your, the class Moodle page. All right, let's see what we got here. Okay, so let's just take a quick overview in terms of the economics and what's referred to as the 3 streams model. It's a little bit of a generalization, but you can see that the latest figures that we've got with much accuracy from 2015, music publishing is in its normal spot, which is the least valuable. This is domestic U.S. revenue, by the way. So bringing in $4.7 billion. What's interesting here is that for the first time in the U.S., live performance has outstripped record sales. Record sales has been at least a 2-to-1 kind of favorite, I guess you could say, in terms of value over the other 2 combined, until the kind of fortunes of the record companies started to shift dramatically in 2000 with Napster, and then all of the peer-to-peer file sharing services that really knocked down the means of access or protecting access to their property. And so live performance, the concert industry has overtaken record sales, and the growth of digital is significant, but there's been, almost half of the physical here is in vinyl record sales, which are coming back. They're now to the point that they were when they dropped off of the map, I think in about, it was either 1990 or maybe 91. But so those are some of the dynamics of the music business. In any case, what I wanted to focus on here is simply that music publishing is a representation of ownership of Circle C, so who has the rights to the composition and the lyrics. And then the publisher simply turns around and out to any number of players. The most prominent players would be the record companies would take out a mechanical license for the right to duplicate that song and record it in a studio performance, and then make mass duplication of that in the form of MP3s or whatever. And in the concert industry, you've got the right of public performance, which is exercised by venues, concert venues, as well as broadcasters. So ASCAP and BMI are the collections agencies that collect from venues and television, radio broadcasters, the internet, and pays the music publishers. The record companies pay the music publishers. So this is a ownership sort of licensing entity here. And here you see an example of a couple of users. So that's a little bit of the structure. We'll get into more of that next week when we look at publishing in detail. All right, let's get out of here. Okay, so copyright in the context of trademark and patent. Patent is going to be these are all government or federal institutions of for the protection of intellectual property. Patent is going to protect inventions. Trademark and service mark is going to protect any of the logos or designs that are used to differentiate products on the open marketplace, like Apple's, or the Nike swoosh is a good example, or the Apple for Macintosh. those are protected trademarks. Copyright, on the other hand, is going to be a form of intellectual property or even physical property. Intellectual property which can be distributed via physical products like compact discs, but copyright does protect intellectual property, and it does not protect ideas, but instead it protects once those ideas are played out and fully expressed by a creator of some kind. And in exchange for that, they get these 5 different rights to distribute the work, to make duplications of their work, to synchronize it with in visual media, to publicly perform the works, etc. So that's a little bit of how you can understand trademark in the context of these other federal systems of protection. In the case of copyright, it's important to understand the dynamics for how the law understands strength of protection, or the status of a work in its be protected oftentimes has to do with its concreteness. So let me give you some examples. So a work that's registered with the U.S. government would be the easiest to protect. So it would have a very strong claim to ownership. A song that's just simply performed live and not recorded and is kind of in the memory of the witnesses, that kind of evaporates with the air. It's very transient, and so it has a very difficult time claiming ownership. So it's considered to be in a very non-concrete form, and so the law understands copyright ability in terms of concreteness. And so you can see this is a sort of a spectrum, if you will, of concrete. The other criteria that the government Copyright Office or a court of law will be looking to establish in terms of a claim to copyright protection will be the expressed fixation of an original idea. Originality is, it's understood that there's no truly original work ever since the first cave paintings of 20,000 years ago. It's already representational art, so originality is loosely defined as a combination of probably at least 3 preceding works in an original way. So originality starts it's understood it's a recombination of existing works. But it's this kind of creative idea that is expressed, so it's developed through the refining of multiple drafts before it's finally put down in its best performance and saved in a retrievable form. And that's really key here, whether it's a recording or an email that's written down, poetry that's written by hand, a film that's kind of in its last fixed, it's in a fixed state. And so when you talk about copyright protection itself, it really begins at the moment that this finished draft comes into existence. So it doesn't depend on a federal copyright protection application for copyright with the government. Instead, it just has to have all of these elements together, and then it's recognized that federal copyright protection will begin at that point. Now, there are some benefits, of course, for registering with the Copyright Office. You get a stronger status in court. Your presumption of ownership, prima facie evidence, is in place with that registration, but it's not actually required for federal protection. What's actual copyrightable? These items over here are eligible for copyright. On the right-hand side, public domain is the opposite of copyright. These are works for which there is no protection. Works of the government, for example, are not there for profit, but they're there for the use of the public. And so there's no reason to protect them. They are to be distributed and owned equally by the public, so they're considered to be public property or the domain of the public. So these items are not copyrightable. On the other hand, on the right-hand side, eligible for copyright protection, we see the things that are distributed in the mass media and the entertainment industry: musical works, drama, motion pictures, even architecture, sculpture, plastic arts, photography, literature. So those are items that are eligible for copyright protection. Okay, so apart from these standard terms, there are three sort of statuses, I guess you could say, that copyrightable works can fall into. We mentioned the public domain. A copyrightable can be a copywritten righted work can fall into the public domain when it loses its protection. Most commonly, it's the term of the copyright that will expire, and then a work will become public property, and so users no longer have to have any sort of permission to access those works. Another unique status of a copyrightable work is a derivative work. These are works that are based on previous works, so they're derived from works, and if those previous works are copyrighted, then you have to have permission from the original owner to make a derivative of their work. And what makes them unusual is that really you've got a new copyright that's not fully 100% belonging to the owner of whoever created this derivative work. Most common examples here would be books turned into plays, works that go into a new medium like books on tape. Those are considered to be derivative works, and so in that case, the original author would have their original copyright would not change in any way, but the new work that's based on the original work would only have a certain percentage of a copyright, of a full 100% copyright, based on whatever it is that's new that's being brought to, and that's being added to this existing work. So that's a kind of a status, I guess you could say, of a copyrightable work. And finally, work for hire. That's something that happens to a copyrighted work in the situation where you've got an employee-employer relationship. It's very powerful and potentially dangerous language for, say, a recording artist who's working with a record company, signs a contract that has work for hire language in it. That means that whatever that recording artist creates will never belong to them. The presumption of authorship is stripped from them because they're seen as an employee, and so therefore it's the record company or whoever the employer is that is designated as the author and therefore the owner. So that's an interesting dynamic to look out for in copyright. We'll look at these a little bit more closely. The public domain, is an interesting concept. There is no way to find out everything that's in the public domain. It's nobody's job to do that. That being said, you can pay the Copyright Office $150 an hour to actually search to see if a specific title is in the public domain or if it's still protected. If you're able to locate original sheet music from 1922 or earlier, that specific version that's on the sheet music is public domain because copyright only protects intellectual property that's from 1923 to present. You can research BMI and ASCAP. Those are performing rights organizations, or PROs. Search their websites, and there are tricks to find out if a given song is likely to be in the public domain. But these are kind of like research. Hence, you're going through their databases to find out about specific titles. The only catalogs that exist that include a lot of works, but they're not comprehensive, so it's not everything that's in the public domain. There's a website, publicdomainreports.com, or ASCAP Hit Songs, that's a book. The Mini Encyclopedia of Public Domain Songs, that's also a book. These have a lot of titles that are known to be public domain. And so that's a little bit on the public domain. Derivative works. So derivative works, I call these the rescued because the example is that I like to use is, say, a work that was a hit back in the 50s, may have had 10 or 15 years of profit and has kind of gone dormant. Um, a creative, a contemporary creator, an artist may come along and say, I want to kind of resuscitate this work and do something that's based on it, that's inspired by this previous work. And in that case, the previous work will benefit from this new derivative work, but it's incumbent on the contemporary creator to discover, to find out who the owner of the original work is, and to secure permission um, to do that. And that's not always a given. Sometimes the original owner feels like the new work will, you know, tarnish the reputation or somehow reduce the brand or the value, the market value. So I'm sure there have been some interesting conversations along those lines. In the music business, examples of derivatives could be a new arrangement of an existing work. If you're adding verses to an old song, it's very common in commercials for them to take like an established children's melody, um, like you know, Three Blind Mice, and then add new lyrics to it about whatever their product is. Um, so keeping melody and adding new lyrics, that's a comment. That's what that was. Um, Now copyright law does provide for minor changes without getting into this derivative business. So if you're a songwriter and you want to change the key, or I'm sorry, a performer, you want to change the key or the rhythm, make it faster, slower, change he to she based on whatever gender you feel more comfortable singing about. You don't have to worry about getting permission. Those are all allowable. And finally, works for hire. These are the lost once again because the ownership is stripped from the creator and assigned to the employer. And that can be a corporation with very little or no creative ability. But because of that employee-employer relationship, the ownership, the copyright ownership, is lost to the creative entity. Okay, let's talk a little bit about infringement types. So Circle P, you can see I've got up here, is referring to, once again, the phonorecord. And so these are copies of a recording, typically produced and distributed by record labels. But with every passing year, it becomes more and more independent producers can assume that same position, or even music publishers can have their own in-house kind of recording studios. So the function of the record label is more open than ever to being emulated by any number of players along the in the constellation of the music business entities. In any case, so bootleggers, counterfeits, and pirates. So bootlegging is a name that comes from 1920s prohibition. People who would sneak liquor around in in their boots, hidden by their pants or whatever. This is used for the unauthorized duplication of live performances because of people who go attend concerts with a small recording device hidden in their clothing, and so that's a kind of similar analog to the old prohibition days. A counterfeit, however, is a little bit different. That's if you've got a recording and you not only download it or duplicate the waveforms, or turn it into an MP3 and make a bunch of copies of that on your computer or on your device, or by CD, burning a bunch of CDs. But you're also counterfeiting, duplicating the original label and artwork and liner notes and everything, trying to make it look exactly like it did when it came out of the factory. That's a counterfeit. So one easy way to remember that is, like a dollar bill, you're not going to put your own face in the. If you're going to be a counterfeiter, you're going to make it look exactly like the original. Pirate, on the other hand, is only interested in the content, and so they're going to duplicate the waveforms via MP3 or whatever it is of the songs, but they don't care about whatever was the the label or the artwork from the original issue or the liner notes. And so that's why pirates, internet exchange of music files, typically don't come with any of that extra material. So that's why pirate is the name that's assigned to them. Bringing a suit, who can actually do that? You've got the owner, so a songwriter, music publisher is another one, because when songwriters sign deals with publishers, and it's publishers' job to basically market the songs, um, the copyright is actually transferred temporarily, usually for 3 or 4 decades, to the publisher, so that they have the necessary incentive to get the material out there into the marketplace. An assignee, so that's someone to whom the copyright is temporarily assigned. An exclusive licensee, so take for example a publisher that's working with a film company, like a film production company. The film production company is not going to want anybody else to be using the song while their film is on its run, and so they would sign an exclusive licensing deal with the publisher. And as such, if someone did use it, the film publisher would then, the film company would then be in a position to actually bring a suit, because they have the exclusive rights to that for a certain amount of time, usually a year or maybe 10 years. So those are the three types of entities that can actually bring an infringement case to court. When it comes to you know the actual trial, you'll notice that based or similar to what we've already seen in terms of, I think it was the Shampoo movie, where the court was able to show that the screenplay that was submitted was actually similar to the work that was released. They couldn't prove access, and so access and similarity are necessary in proving the case. When it comes down to defending the charge of infringement, here you've got a selection of about 6 different common defenses that are used, from strong to weak. So the statute of limitations, of course, means that the case is null and void between the perception of the fact that the infringement has taken place and bringing the case to court. You're typically talking about 2 to 3 years, by the way, for music business in any case. Independent creation simply means that there's no need to steal, because the defendant has a history of independent creation. They can make their own songs. Innocent intent is a very weak defense. It's kind of like saying, "Oops, was that me? Did I do that? My bad. I didn't mean to do that." So you're still going to get a penalty, but if you can demonstrate that it wasn't done with malicious intent, or that it wasn't done like on a criminal level, so you're not a repeat offender, doing it on a mass scale, then this can bring down the hold on a second, the penalties a little bit. So those are some of your defenses. Fair use I had in bold because of the fact that it is a lot of gray area, I guess you could say. Meaning, so there are certain instances where a non-owner can use copyright protected material without permission. So allows unlicensed use without the owner's consent. So the profit versus non-profit. So there's a 4-factor test we're going to see in a second that really is the beginning of determining whether or not something is fair use in a court of law. Profit versus non-profit is always the first thing. So if the use is profitable, then it's most oftentimes not going to be fair. So, but if it's nonprofit, like in the case of teaching, research, journalism, or worship, then there's a chance that the use could be fair. A chance. But look at the bottom here. This parody instance is the one that is the gray area within that, because the government, the U.S. federal government, is interested in preserving the ability of the public to comment, to make fair comment and criticism on the work itself. And that's what parody is. Now, satire is if you're using the work to comment on the morals of society or social norms. Okay, that's not protected. So it's kind of splitting hairs there. Okay, here's the four-factor test I was talking about. So what is the purpose of the work? Is it profit or not profit? We covered that. Um, does it have an effect on the market value of the original? If it does, if it's usurping the original work's ability to actually, make profit and enrich the creator, then that may be deemed to be not fair, not a fair use. Um, how much of the original work is this secondary use actually working? I mean, secondary work actually using. Sorry, I got those two mixed up. Um, so you'll see when you look at your court cases that this four-factor test is very prevalent, and you'll get a little bit more detail there. Let's see, technology and legislation. Okay, so yeah, the safe harbor provision from the Digital Millennium Copyright Act of 1999 or 2000 basically said that there are ways to protect um, internet service providers from infringement, and that they are should be considered as being exempt because they are providing the service, but they're not actually doing the duplicating. And so this was this is some language that you're likely to see, safe harbor. This is there's a lot of debate about whether or not safe harbor provisions are being properly applied or not. That's the general spirit of what that is. When you get to the types of infringers, so the law breaks infringers into three different sort of categories. A direct infringer, one who's actually doing the crime of the duplication, but there are these other two levels of infringement: contributory and vicarious. So a contributory infringer will materially support the act of infringement without doing it themselves. So I'll give you an example here in a second. But the vicarious infringer is someone who will be benefiting from the infringement but doesn't even have to know that it's taking place. Now, the rationale for these three categories is that oftentimes infringement is perpetrated by performers or artists who have very limited financial means, and so they may not be able to pay the full penalty. And so the law has adopted this sort of expanding bullseye type of response to that situation, where if an artist is found guilty of infringement, they may be bankrupt without settling the entire penalty. And so the bullseye then expands to the next associated party. The contributory infringer will then be liable for the remainder of the amount of money due. And then finally, vicarious infringer would be the last sort of associated party that's involved that could then also, if the contributory infringer can't pay, then the vicarious infringer would be brought in and found liable and subject to pay as well. Okay, here's a practical example. So the recording industry program here has a student-run record company named Indie Blue Records. Let's suppose that they're promoting a concert where one of the acts does a cover song. So it's a cover song is a song by another artist. So they're covering another artist's material. But the venue doesn't have, there's no performing rights organization, PRO license to actually perform from ASCAP or BMI. So in the absence of a PRO license, any act is restricted to basically doing their own material, original material. So think about it. Who's the direct infringer in this situation? Who's contributing to the situation where the infringement's taking place? And who's sort of sitting back and benefiting from the fact of the infringement, but not actually contributing or doing the infringement? Okay, think about it. What do you think? Okay, I went too fast. Okay, so the direct infringer in this case, of course, is the artist. They're the ones on stage duplicating the song. They're duplicating the performance. Who's arranging for this festival or whatever it is, concert to take place? That's the record company. That's Indie Blue. They're promoting the concert, as you can see. Indie Blue is promoting the concert, so they're contributing. They're providing the materials, the marketing for this to take place. They're providing the structure in a way. But it's the venue that is passively sort of benefiting from the fact of this concert taking place, but without materially supporting. They're receiving the rent from the concert that's paid by Indie Blue Records, but they're neither doing the infringing, nor are they organizing and kind of directing and driving the organization of the event. They're just a third-party contractor, I guess you could say. Okay, so that's how the law would see that example. Direct and circumstantial proof. Okay, so in an infringement case, it's almost never the case that the defendant is just going to come out and say, yeah, I did it, and here's a videotape of me doing it. So there's no direct proof. That would be a confession or some smoking gun evidence. So 99% of these cases are going to be circumstantial cases, meaning that the events of the infringement have to be reconstructed. And so the grounds of the reconstruction rest on this two-part kind of access and similarity. So did the defendant have access to the work that they are being accused of stealing? And how similar is their work compared to the one that they are being accused of, to the original work that they're being accused of stealing? And so there are weak grounds of access and strong grounds of access. When a weak example could be a songwriter goes to a concert for an artist, and they want to give the artist their song to consider using. But instead they give it to their manager, and then the manager allegedly gives it to the record company, and then the record company gives it to a producer. So the more you get these degrees of separation, it's more sort of convoluted and less likely. It's much stronger if the artist says, yes, I recall, I received the CD or the MP3 file from the songwriter. Then you've got a stronger case of access. Similarity, will a regular person find that this is strikingly and evidently and obviously similar, the two recordings, when you play them next to each other? When you have to break it down into these minute details and look very closely, then it becomes weaker and weaker. Okay, so the last thing I want to go over very briefly is the penalty phase of the trial. So these are almost never criminal trials. Criminal means that you've got a repeat offender that's doing it on a very large scale, and criminal penalties are the only ones that you're going to get into, like corporal punishment, like putting somebody in jail, for example, would be that's a criminal penalty. So the vast, overwhelming majority of these are going to be civil cases, and so and you're just dealing with money basically here. So a civil case will sometimes just involve like an injunction, which is a judge's order to cease and desist a certain activity. So if you're distributing a work that is found to be infringing, then an injunction would be sort of a light slap on, or it's on the lighter side of these penalties. But it simply says stop what you're doing, and that'll be enough. So cease and desist. Confiscation is when the infringing materials are confiscated by the courts. Destruction is when those materials, and this can be the actual recordings, but it can also be the materials that were used in the duplication of the recording, can also be destroyed. And then finally you get into the lost profits. That profits that were lost by the plaintiff can be awarded, and also various types of damages can be awarded, including a per unit cost, which would be a statutory damage, or actual damages if those can be proved by the plaintiff. So that's basically what I've got for you for these copyright cases. You'll be seeing a lot of this terminology, so I hope this has helped you out. And have a very nice week. See you next time.